Hello everyone, in this video I will talk about a real case I handled recently. A student reached out to me in distress because his visa had expired. He had submitted a fee waiver application, probably thinking it would buy him some time. Then someone advised him to apply for further leave to remain on human rights grounds, even though he had no strong basis for such a claim. Here is why that was a bad idea. Number one, he had not completed his degree. Secondly, he had no compelling human rights grounds under Article 8, right to private and family life. He was not seeking asylum. He lacked strong evidence to justify on FLR applications, further leave to remain applications. A weak further leave to remain application is rarely successful and can damage future immigration prospects. So what was the solution that I told him? I took a closer look at his case and found out he actually had enough money to pay the university the remaining fees which he had not paid. And therefore, because he had not paid the university the remaining fees, the university did not provide him the confirmation that he has completed the study. If you do not have that confirmation from the university, then one cannot apply for the graduate visa. So I told him that he needs to go to the university, pay the remaining fees, which he did, and then we made his graduate visa application. Instead of going for an further leave to remain application, we submitted a graduate visa application while his fee waiver application was still pending, which we made. 3 weeks later, he got an email that his graduate visa was granted. His fee waiver application didn't even matter anymore because his immigration status was now regularized. So what are the key lessons that we can learn from this case study? First of all, avoid weak further leave to remain human rights applications. A weak case can lead to refusals and affect your ability to stay in the UK. They can put you in the immigration bail, and if the fee waiver was, for example, accepted, later on if further leave to remain was rejected, then they can put you on the immigration bail. So then you cannot even switch back to graduate visa or any other point-based application like skilled worker visa or maybe student visa. You will not be able to switch into that because you are on immigration bail, and there are limitations if you are on immigration bail. Secondly, consider the graduate route if available. If you qualify for a graduate visa, it's usually the best and most straightforward option. Thirdly, explore alternative routes. If the graduate visa isn't an option, look into switching to a visa based on relationships with British citizen or settled person under Appendix FM or work-related routes. My final thought on this will be applying for a further leave to remain application on weak grounds is a risky strategy.